Hey guys, welcome to the Atlanta Landlord Luncheon. Meets every third Monday of the month, and our goal is to bring you monthly education, market updates, and networking events to help buy and hold investors build long-term wealth through real estate. You're welcome to join us on Facebook, LinkedIn, and YouTube. You can just search for the Atlanta Landlord Luncheon, but we would love to connect with you. My name is Matt Martin. I am a property manager and real estate agent at PMI, Georgia. We offer investors simple, straightforward property management with Southern hospitality. We manage over 400 homes throughout Metro Atlanta and Middle Georgia. The vast majority are single-family homes, but we do a lot of small multifamily properties as well. So if you'd like to learn more about how we can help you protect and grow your investment portfolio, you can check us out at pmigeorgia.com. Also joined with Chip Cagle of Longhorn Investments at Hobnob Tavern. And Chip, let me unmute you real quick, and I'll let you introduce yourself.
All right, thanks, Matt. So I'm Chip Cagle. I'm with Longhorn Investments. We do hard money loans for your fix and flips, new construction, and we just started doing DSCR loans about 6 months ago. That's rental loans, 30-year rental loans. So I'd love to talk to you about all those things. As far as the fix and flip goes, we lend 100% of your purchase and rehab. That's 100% of the costs, up to 70% of the appraised ARV. We can even go to 75% if you're planning to keep it as a rental property. And we've got a couple of specials going on right now on the fix and flip. You can choose a discount. You can choose to either have a half a point lower than usual or 1% lower than usual. You get one or the other, not both. If it's gonna take you less than 6 months to do the renovations, then probably the lower point would be better. If it's going to take you longer than 6 months, then the lower interest rate would definitely be better. So we also have another special where if you're already an investor, have some experience, but you've been working with other investors, not Longhorn, or maybe you even had one loan with Longhorn, but you don't quite have enough with us yet to get into our customer loyalty program. You can use your experience with other lenders to get into our customer loyalty program. Now, it has to have been paid off along with another lender, paid off in the last 2 years, and we need 3 of those. If you got 3 loans paid off in the last 2 years, you can jump right into our customer loyalty program, and on that, you get 1 point lower and 2% lower on the interest rate. New construction loan is not 100%; it's only 90%. But we can get that done for you too. I'll talk to you about that and talk to you about the DSCR loans. For those who aren't here in person, my phone number is 404-216-5599. Thanks, Matt.
Awesome. Thank you so much. All right. So we are joined today with Andrew Gurvey of Gurvey Law, and he's going to be sharing with us about Georgia landlord law for 2026 strategies and liabilities. So Andrew is a licensed Georgia attorney practicing with over 20 years in real estate law in the Atlanta area. And although he's been almost exclusively transactional, he's also run title, foreclosure, eviction, and litigation departments of several mid-sized law firms. And he continues to provide real estate legal expertise to others and serves as in-house counsel to a large Atlanta builder. Andrew is also an active investor and has rental property of his own. He's got a lot of great resources on his website as well, and a great resource to talk to no matter what kind of deals you're looking at doing in the Atlanta area as an investor. Also involved with charitable organizations as well. So Andrew, I'll let you take it from here and share a little bit more about all the things you're involved with.
Thank you. I think you covered it all. Most people I run into know me, heard me. I've been doing this for about 25 years. I'm all over social media, never holding back, commenting on people's posts, telling you like it is, and probably offending quite a few people. There's nothing like somebody that is got an opinion that's wrong and I'm always willing to give a different perspective. So happy to speak to anybody if you've got questions outside of this presentation, or if you run into me. We have events at my office, networking events. We have one coming up February 5th. Please reach out. Feel free to join us. 6 p.m. at our office, drinks and food. There we go. So we dive right into it.
Yeah, all right. That sounds great. I got it pulled up for you.
I've got about an hour or more of material that I'm going to try and squeeze in to 15, 20 minutes, and then room for discussion. I guess a couple caveats. One, I don't do anything with tax. If you have tax questions, ask your accountant or CPA or tax attorney. I also don't handle any litigation myself. So if you're looking for someone to handle evictions or sue somebody or get into a lawsuit, I can certainly give you my opinion on it. Most of the time it's going to be cautionary. And if I think that there's a case, or if you're passionate enough about it, I can refer you out to somebody that handles litigation. And of course, they all ask for a hefty retainer. So unlike personal injury or workers' comp cases, they're not going to, do this contingent on a positive outcome. The other is in this presentation, with landlord-tenant law, there are a lot of timelines. I'll mention some, but if you're looking for, just like a short list of timelines for giving notices and evictions and letters and answer responses, all those are detailed. I'm not going to cover those here. You're welcome to look things up. Google is your best friend. ChatGPT sometimes, although I question some of the answers it gives. You don't want to rely on that. And, you can always find a litigation attorney and pay them for a consult and get the specific answers for your specific issues. So that being said, we're going to talk about landlord-tenant law, landlord-tenant issues, things that are effective in 2026. A lot of them didn't come into play exactly in the last 19 days, but they apply. So really, to kind of start this off, we're going to go with, there's some must-know things about leases, deposits, repairs, evictions. There's some updates. One of the significant one was as of July 1st, 2024, which was the Safe at Home Act, House Bill 404, which has passed and is applicable in Georgia. Everyone should know that. Although I question if how exactly they ended up with a House Bill 404 that's the main area code for Georgia, which seems a little odd. But overall, Georgia is still a very landlord-friendly state, thank goodness. But the easy defaults, the things that you think you can rely on, those are getting fewer and fewer. The ultimate thing is to be able to plan ahead, not have so many surprises, and make sure that you're compliant with the things that can really flip you around. So that being said, the framework for all of this, and if you're a hands-on person or even want some light reading, my recommendation is that you grab a copy of the Georgia Code, Title 44, Chapter 7, which covers the everything you wanted to know about landlord-tenant law in the state of Georgia that you were afraid to ask. It is where everything is based. It's the one volume that is certainly, it's updated, but it spells it all out. One of the things that you need to know also is your evictions typically are going to end up in magistrate court, and you need to know those processes and procedures. It's not one that you can screw around with. I'm often in in the smaller courts for like City of Atlanta for code enforcement and everything. And, you know, I was working with a lot of times the chief judge, very lenient, very laid back, and he's been replaced for the last year. And now it's super procedural. If I don't file an entry of appearance, you know, in the lower court, he will kick me out, tell me to go down, file one, and then when it's done, then I can come back and talk to him. You know, those little things, following those procedures and timelines are going to be super important. You know, things like, you know, for non-payment of rent, you've got to have a 3-day written notice, you know, to your tenant. That's a requirement. You know, there's, you know, a bunch of federal regulations that supersede everything that, of course, everybody should know, and that's banning discrimination. There are certain protected classes. You know, you can't not rent your place to somebody in one of those classes. The other is the Service Members Civil Relief Act. That also has a significant effect, which gets into, you know, things like being unable to evict a service member immediately, always having to go through the courts for eviction. And then, of course, you know, somebody filing bankruptcy, and then, you know, it sort of kicks your plans for the next few weeks, you know, completely on its head. So those are those, you know, little things that you need to kind of keep in mind. Running ahead, you know, the one thing that I would say is significant for a landlord in Georgia is making sure that you're always using a written lease. Spell out the rent, the late fees, the fees versus deposits, how you're handling everything, how maintenance is reported, access to the property, when things renew, when things are terminated. Certainly avoid, and I mean avoid illegal clauses. Those are things that you just don't want to even get near. And they're simple things that you would think that, well, you know, I can have this agreement with my tenant, but, you know, that's fine if they want to act on that, and if it's just like a handshake kind of thing. But if it ever gets nasty and you end up in the courts, these are going to be thrown out. And, you know, there's some things that come back to bite you really hard. You know, a lease cannot, you know, always requires, well, the dispossessory process always requires a judicial process. You can't waive that. You can't have in your lease that, you know, X number of days after non-payment of rent that the landlord can move all possessions out or change the locks or things like that. That's considered to be self-help in Georgia, and that's not allowed across the board. Violates dispossessory statutes, due process. If you've got clauses in there, the magistrate courts will ignore them completely. And I mean, imagine just your 20-page lease that you think is, you know, rock solid, and the court just going through it with a red pen going, nope, that's not, nope, not that, and then finding you at fault for a wrongful eviction, or something that's even worse that opens you up to, you know, certain liabilities and penalties that just, you know, one is going to keep you away from possession of your property, but also have you paying out fees that you were thinking you were getting. Self-help eviction clauses. Yeah, Matt.
Andrea, I was just going to say, just in, you know, my calls with, you know, potential clients and things like that, I see a lot of confusion in this area. I've seen, and the funniest thing, because people get into real estate investing to make money, right? The goal is to make a profit, and little things like this can really cost them big on the back end. So I would definitely say your two options for having a written lease are to pay an attorney to prepare one for you, or hire a realtor or property manager to lease your property for you. That's really the only two
Sure.
options. I've seen so many things left out of leases, and then just, people watch YouTubers, and something that might be legal in another state doesn't apply here. And
Yeah.
even things like, oh, I require tenants to handle maintenance up to a certain dollar amount. There's a lot of things that make sense on YouTube, but it's very different when it comes to what you can enforce in court, and
Correct.
how to be safe and profitable.
Yeah, I would say, pulling a lease off of a website, some legal document company or whatever that's generic or covers the entire state, or for some investor group, is potentially problematic. The GAR forms, the forms that most realtors have access to, are typically drafted and edited by some of the top attorneys in the state of Georgia. So I'd say, those can be pretty easily relied upon. I'm always an advocate for natural language agreements. You don't need any special language. You just need to spell it out so that it's clear. There are so many cases where ambiguity screws over the parties. There's some significant ones, which we'll hope maybe have time to get into, that are just nuts. Read the cases and, like, what in the hell were these people thinking? But it all comes down to being very clear, making sure that you don't have any of these provisions. The self-help stuff is really problematic. You'd think you could, oh, they don't pay. Well, you can change the locks. I can shut off the utilities. I can remove some doors. I can, you can't do any of that. The landlord can face damages, punitive damages, depending on the circumstances. And even if the tenant agrees to it and, waives any rights or claims or whatever, the court's going to say, yeah, you can't do that. And they're going to put that liability back on the landlord. So you need to, make sure you avoid that and just know what your responsibilities are, rather than falling back into, oh, I didn't know. Okay, now I'll do this. At that point, it's too late. There's one big change that's happened in the last couple of years, is a requirement that, that the landlords maintain the property at a level of habitability. And the habitability is not necessarily so clearly defined. So it's more of, is the judge, is a jury going to think that this property is uninhabitable? What exactly is that to you versus somebody else? One of the big things in Georgia, just because of the temperature fluctuations, is having a working HVAC. That's one that, is, you cannot expect a tenant to fix their own HVAC. You cannot, even if it was a minor repair, you can't allocate maintenance to somebody else. And, Georgia law requires landlords to keep the premises in reasonable repair. The other part goes into things like security deposits, where you have something that says any damage automatically forfeits the entire deposit. They can't do that. You can end up, in a lot of trouble because of that. Georgia law requires itemized deductions, timely inspection, a refund of a balance, and anything that's like an automatic forfeiture of X, Y, and Z is going to be completely lost in court. You can't have penalties disguised as fees. Those won't work. Clauses where the landlord's not liable for injuries caused by their own negligence. You can't write your way out of being a negligent landlord. That's one of the things I always hear from investors of, oh, I want to hold my property in a trust. I want to be anonymous. Somebody trips on the sidewalk and is going to sue me for everything that I have. That's ridiculous. If you want to be anonymous to keep your property out of view of a girlfriend, a boyfriend, an ex-spouse, future spouse, somebody else, that's fine. But ultimately, a tenant needs to know how to get in touch with the owner. Somebody falling needs to be able to get in touch with whoever they need to get in touch with. You and your 2 rentals or 20 rentals or 50 rentals is not a target compared to, a hedge fund with 1,500 doors under one LLC in Georgia and a registered agent that's down on Peachtree Street that can easily be found. Keep your property maintained. Have your processes in your lease as far as repair and notice. Go through walkthroughs. Make sure that things are in repair, and fix them timely. That's the simple stuff. Have an insurance policy. Those should be, basic. So that's just one of those things. And in a company that is, managing your property, that's also a thing. I have somebody managing mine, and I keep my fingers crossed that they're doing everything right, because that's what you pay them for. The Safe at Home Act, just moving on so we can get through a lot of this stuff. So that was effective July of 2024. There's a habitability standard. Landlords must maintain rental properties in good repair and fit for people to live in. That standard is now legally included in all rental agreements. Should be. And there's a security deposit cap, 2 months rent. You can't go more than that. And of course, the eviction grace period, tenants have an extra 3 days to pay rent. That's the little notice. They have a right to cure before the landlord can file for eviction, requiring formal written notice tacked to the door. Other expansion of definitions include essential utilities are like cooling, meaning landlord can't shut off air conditioning to force a tenant out. You don't want to be that landlord. So generally it's greater protection for tenants, but there's usually, for a landlord, you're just talking about an increased investment in the property maintenance, new service standards, property managers needing to adapt to new compliance requirements. The other thing I think everybody needs to certainly know is that if you're not living in the state, you need to have a licensed broker representing you for your properties. So don't think that you can retire to Florida and still manage everything on your own. It might work for a while, but if something happens, it could come back to bite you.
Yeah, Andrew, that's a new one we've been trying to spread word about, but it's really kind of unclear as to how enforcement happens. I just assume you will start seeing things go to court and maybe the judge asking who your licensed representative is. I mean, I haven't really heard of anybody being penalized for this yet.
Yeah, I mean, it until there's something that happens that's nutty, and and there's always going to be one of those cases. It just hasn't happened yet, but the framework is there, and in general, I think most landlords, I'd say the majority of them are here in Georgia, and probably do have somebody that is a representative. So, you know, hopefully that's not something that's going to be so much of a problem.
Yeah,
You know.
it probably 50%, I'd say, of clients we work with are out-of-state investors. But I
Okay.
know that there's a lot of, you know, bigger pockets. There's a lot of podcasts out there that really advocate for being an out-of-state investor and how you can be a landlord from a distance. And so I think
Yeah.
it'll take a while for people to become aware that they're going to need an in-state broker, property manager to
Yep.
manage their property. So
There we go. So anyways, the new stuff, fit for human habitation, it's not waivable. You know, document your work orders and response timelines. Keep on top of that. You know, fix it fast is cheaper than defend it later. You know, train your team. If a tenant says mold, no heat, leak, rats, electrical, treat it as legal notice, because all of those are buzzwords that are going to affect habitability. You know, and I've seen things where, you know, on Facebook, people are talking about, oh, I've got this ongoing issue with my landlord, and there's mold in the apartment, and I can't live there, and I have, you know, allergies, and I've been to the doctor back and forth, and you know, that's a mess. You know, keep records very clear, so that, you know, if you've got to present stuff to a judge, that within a short period of time, a minute, 90 seconds, you know, that they can review and understand what's going on. They reported no heat. We got a, you know, repair team out there within 12 hours. This was fixed. You know, we entered the apartment to check. We noticed that all the vents were covered with cardboard and masking tape. We removed them and the temperature went back to normal. You know, I mean, little things. You know, I mean, I've dealt with some attorneys and we've handled lawsuits earlier in my career where, you know, simple things, exposed wires and kitchen outlets electrocuted a tenant and caused her to miscarry. You know, those things shouldn't happen at all, not to the tenant, and certainly the landlord shouldn't be having a property that's like that. You know, there's one thing about, I mean, you know, in you know, some other cases they talk about, you know, and I forgot exactly the term, but about a banana standard. Okay, the slip and fall cases. There are actually a lot of slip and fall cases that have to do with a banana peel on the floor. And what's relevant in there is the condition of that banana peel. Because if you've ever eaten a banana and taken the peel and set it to the side, you know, it'll be nice and yellow. But within a couple hours, it'll start browning and turning black and starting to decompose. So, you know, things can happen in a house. Somebody can swing a door around and, you know, it will, you know, crack into sheetrock. It's another thing if somebody, you know, runs into an outlet and breaks the cover. It's another thing when the outlet's unscrewed and the plug's pulled out. It's another thing when it's twisted and then the plug's missing and then the wires are out. So, you know, it just sort of depends where in that stage the damage is going. You know, if the floor is wet, that's one thing. If the wood is rotten, that's another. If it's collapsed, holy crap. Why isn't the landlord aware of it? Why wasn't this caught in an inspection? Why didn't the tenant notify them in writing as required by the lease? And why weren't the repairs made? Those things are going to come up. So they should. There's a whole thing, OCGA 44.724 about retaliation. You know, that's a fun little read. Talks about tenants in good faith exercising attempts against the landlord about notice and repair and timeliness, complaining to a government entity, responsible for enforcing building codes, making claims. There's a layout of how the retaliation, essentially from a landlord saying, oh, look, I did all of this because they were complaining about something, that the court can follow and find out. Essentially, a tenant can recover from a landlord a civil penalty of 1 month's rent plus $500, plus court costs, plus reasonable attorney's fees, if their conduct is willful, wanton, malicious, and you don't want to be in that environment at all. So, it'd be nice to be able to say that, okay, they didn't pay me and I changed the locks and I moved their stuff to the curb, and I just got a new tenant in that's a lot nicer. Yeah, you can't do that. You don't want to do that. Security deposits, again, have your move-in inspection, have return deadlines. There are, now in House Bill 404, 2 months rent is capped for leases that are covered for your security deposits. The deposits are procedural. So if you miss a step, you could lose the offset rights, even with, real damage that's there. If you fail to return any part of a security deposit, you could be sued for, or they could collect 3 times the sum of what's been withheld, plus reasonable attorney's fees. That could be a lot. I mean, you think that you've got $2,000 in a security deposit, and if you, don't itemize, if you don't, show that this is why you're retaining it, that, you're talking about $6,000 plus attorney's fees. That's a chunk of time, a chunk of money, a chunk of liability. So you want to make sure that you're away from that. There are a bunch of different ways to terminate a lease. There's tenancy at will rules under 4477, 60 days for a landlord, 30 days for a tenant. At the end of the term, tenant must deliver possession, and there's a dispossessory remedy for the landlord. If not, holdovers can be a different tenancy if you mishandle rent acceptance. That's one of the big things, I think, for landlords is, if you have a huge chunk of rent that's due and you're trying to evict them, and then at some point they're waving a bunch of cash in your face, be careful about taking that, even to offset what you've got. Either, you want the tenants out or you want to work out something with payment. Be careful what you accept. I had a situation years and years ago where I was getting out of a lease for an office, and I tendered keys over to the landlord, and they accepted, and I walked out. And then we had a small lawsuit that covered the landlord's acceptance of my keys without reservation, and I ended up paying a small settlement, which was a fraction of what was owed in the rent for the business. But there's little nuances that the landlord should have known about, and he found out about afterwards. But payment of rent in that case wasn't one of them. So there you go. And as management company, Matt, I'm sure you know about that. That's the fun stuff. Anyways, dispossessories. Those are fun. They're problematic in Georgia. They can take forever in the courts right now, depending on the county. They can be expensive. The last one that I did, it took us 4 months to get a writ. And then we were on a waiting list for the marshal, and I ended up deciding to go with a private marshal. that was $700 or something per marshal. And then I had my move out crew and then the dumpster. You know, you're thousands of dollars in. The practical part of this that every landlord should know is also, you know, the idea of cash for keys, and you got to balance that out. And I say this as an active landlord, as a closing attorney that works with a lot of you know, transactions, purchases, sales, and also one where we handle quite a bit of defaults in rental agreements for the nonprofit builder that I work for. You know, that I'm always speaking up when they're months behind on their occupancy agreement and saying, cash for keys. What can we do? Even with a foreclosure that we had recently, it was, you know, what can we offer cash for keys? They refused. It's like, fine, let's go forward with the eviction. On a foreclosure, the process is a lot shorter. I remember being in a small county, I think it was Banks County, where we had the eviction hearing at the judge's desk in the courthouse. And of course, I found out at the point in time that the former owner knew the judge. They had a friendship at some level in small county. And the judge was trying to give her 30 days to respond. And I had to remind the judge that for an eviction that he only had the authority for 2 weeks. He didn't like that, but you know, it was a little bit longer than what I'd like, but he also, of course, was notifying her of her, which I thought was a bit of a bad move on his part, but also notifying right off the bat of her ability to appeal, which would have kicked it a little further down the road. So just one of those things. There's answer periods, defense counterclaims, all that time you can find in the statutes, or if you're hiring an attorney or an eviction company, management company to handle it, you can certainly do that.
And one thing investors may not be aware of is that every county is its own little fiefdom. You know, the court timeline processes can be a little bit different. So it is important to pay attention to the differences in counties, right?
So every county is separate as far as their timelines for getting around to doing it. So that can be the holdup, but they're all still held to the same timeline standards of notice and for answers and all that. That's standardized, but you could still be waiting 6 months for a writ in Fulton County just because they're so backed up. It's a certain timeline to the point of where you can have your hearing, but the hearing might not be scheduled for 4 months. So that's where you get into, you know, other little problems for sure. Yeah. Yeah. One of the fun things that's come up, and I think is relevant for a lot of people that are doing short-term rentals, and you know, it's kind of, and I invite everybody to look up on the internet. It's a nice read for maybe 20 minutes or half an hour. The Subtleties is this case that came up 2022, 2023, Efficiency Lodge versus Neeson et al. You know, it comes off of COVID, and a bunch of different individuals living in an efficiency lodge, like a little motel hotel. I think their advertisement is, you know, stay for a little or stay forever. And these people were staying there forever. And all their paperwork, you know, was very clear. You are a guest. You are not there. You are not a tenant. We are not a landlord. You know, you have access to this room and spelled out, but these people were living there and had rooms with their own furniture and own appliances. And they were there not just for weeks and months, but years. Ones where maintenance wasn't even going, or, you know, like the maid wasn't going into the room and cleaning because they were long-term occupiers of the room. And then a long time went by where they didn't pay the rent. And then it went into court, and they found for the plaintiffs, for the people, because they were claiming they had a landlord-tenant situation, and that the hotel wasn't able to use the lockout provisions. So for everybody, I mean, which, you know, isn't always so common, lockout meaning that, oh, you didn't pay your rent, I'm going to lock the room, I'm going to take all your stuff out, and I'm going to put it into a storage unit down in the lobby by the front desk. Okay, that's allowed for a hotel and for guests. You don't have that privacy right. You don't have the rights of a tenant requiring an eviction. But in this case, because of the way that the intent of the parties, and even meaning intent being by the way that they acted, can change that relationship. So, you know, I hear about it in other states, and I'm not quite sure what those particular laws are. I think a lot of people that are dealing with, you know, like Airbnbs are more cautious about their short-term rentals turning into long-term rentals, and the ability to get somebody out that's squatting. So, you know, but I'd say look at this case when you have the time. It certainly is unique, and certainly in Georgia for that. So, landlord liability. This is the fun stuff. There's a bunch of different cases that are coming from 2024. You know, this Williams Kasulka. This is actually commercial property where this guy it was a nightclub, and a security guard on leased property injured somebody. And so the guy came back and sued the owner of the property for damage that and injuries caused by this security guard by a third party. And essentially the court came back and said, yeah, no, you know, you're leasing that property out. You're not in control of it. You're not liable for the tenant or a third party, such as a security guard. So that's a nice thing. Pollard, there was a step on the exterior of the apartment building that broke, and somebody was injured when it collapsed. And the trial court granted judgment to the landlord, but the appeal reversed it. Essentially, you know, you've got to maintain common area under the owner's control. You know, the court held that when there's a genuine issue about material fact, about whether or not the landlord had constructive notice, you know, you can't just rule for the landlord right off the bat. You've got to show that he did have notice about it, but he should be maintaining the property. Sneed, it's again hazardous conditions at a rental property. There's a contractual timeline. What happened is that a tenant sued her landlord because of personal injuries from the conditions. The defendant wanted to the landlord dismiss because there was a limitation in the lease about when they could bring an action, and the court actually upheld that on behalf of the landlord, saying that the lease created that landlord-tenant relationship and had a provision that you had to bring an action with a lawsuit within a certain period of time. The tenant didn't do that. The court's going to hold to that, saying, yep, they should have brought it earlier. It was past that time. We're not going to allow it. So that's, sort of cool. Landlords win a lot on these cases when there's documents that control exactly what it is, that they're not waiving things that they can't, and very clear on, repairs and notices and timelines. Few things to kind of look for. Of course, House Bill 404 passed. House Bill 399 passed. That's the in-state requirements for landlords and representatives there. 413 is dealing with termination rights if you have fear of firearm violence. That one's been moved on. It hasn't passed yet. It was agreed to in the Georgia Assembly in 2025. So we'll see what happens coming on this year. 876, that one's a little nuttier. This one is, it was filed to amend the landlord-tenant law to give residential tenants the ability to offset rent for repairs automatically. So, if that one comes through, that's a big thing. There's also House Bill 710 that's coming up. Well, it may not come up. It was read, but didn't really go anywhere. It just sort of sat in committee. And that was putting on some limits on rent increases. And I can't imagine that going anywhere in Georgia. I don't think we're there yet. And I hope that we're not. Because myself as a landlord, I think it's hard sometimes to have your rents cover your expenses and your mortgages. So, there's certainly a difference. And I think that as an investor, you look at that and say, all right, what can I get into this property for debt-wise that's going to be sufficient enough to be covered by what the rental market is for this property? And sometimes it just doesn't work out in Atlanta right now. I still think rents are relatively low. Matt, wouldn't you agree?
Yeah, there's definitely been downward pressure on rents over the last 2 years. And that's, we've had a number of headwinds with people not being able to sell for what they paid for. So they're trying to rent out their home. We had a lot of new construction, build to rent, brand new apartment complexes. So there is a lot of inventory, and that's, so in some areas, rent may be down 10%, and landlords are used to rents always going up. But over the past 2 years, there's been a lot of downward pressure in the midst of property taxes going through the roof, insurance costs going through the roof, repairs going through the roof. So there's a lot of risks and costs associated with having a rental property that a lot of people don't consider. So yes, there are times when the market plays catch up, but a lot of times landlords are trying to recuperate costs from, below market rent or, the costs of doing business for them. So yeah.
I mean, it's, in smaller markets outside of Atlanta, I see property costs being low and rents being pretty strong. But, then if you're not in those areas, trying to do that from Atlanta, that's not so attractive for me. But for some people, that's their business model, and they can live in Atlanta and have all these rentals down in Albany and Brunswick, Georgia, and be just fine, and then leave the management up to Matt. But
or Macon or Warner Robins, we do cover that area as well. That's where we've been sending a lot of investors.
So overall, make sure that you have your processes in place. Can you document everything that you can? If you think that you can cut utilities or change the locks, don't. Always go through the dispossessory process. Sometimes you have to start it. Doesn't mean you need to finish it. Sometimes you can, again, pay for keys to get them to move out, or moving expenses. Squatters, that's a whole different issue. But typically you can, you have to treat squatters without, as if they were tenants and need to evict them. And that can be a problem. So overall, checklists, templates, management company, make sure you keep up on, the status of your properties, check in with them, ask if, there have been questions on repairs or issues, or, even set your eyes on the property every once in a while. I drive by mine and, shoot a text to the manager and say, hey, the property is looking like shit. It's grass, there's a limb down, there's this tree, because that isn't going to necessarily work out if code enforcement comes by and cites you for tall grass or whatever other issue is happening with the property. That's still going to come back on you as the owner, and you're not going to be able to, tell a judge that the tenant was responsible for it. They're still going to fine you, and you don't want that to happen. So, as long as, I think that you're a responsible landlord and you're doing what you need to do, then there shouldn't be any problems.
That's right. Yeah. And I said this earlier, people get into real estate investing to make money. But there are very painful costs in learning, very painful lessons in learning. And talking with somebody like Andrew can really save you a lot of money down the line. So, I believe in real estate investing. I think it's a great way to build wealth, to preserve wealth, to leave a lasting legacy for your family. And in order to do that, it's really important to understand Georgia landlord tenant law, how to play by the rules and follow the rules. And, you can have a long and healthy investment in this business. So Andrew, what's the best way that people can get in touch with you, find out more about your services?
I'm not available. You can ask Chip. Chip has all my information. You can find us on Facebook, Gurvey Law, or our website, gurveylaw.com, my last name, law.com. And come by, say hello, February 5th. We have, if you haven't been to my office, we are unlike any other closing attorney you'll find. So.
That's right. I've been there a few times myself, had a closing a year ago there, and been to a couple of the networking meetings. So it's a great, a lot of great investors showing up, lenders, all sorts of people that show up for those networking events. And if you're thinking about buying a property, buyers get to name the closing attorney. So you should check out Gurvey Law and put them on your next offer if you're thinking about buying an investment property.
Thank you.
Yeah. All right. Well, thank you guys for joining us for the Atlanta Landlord Luncheon. Chip's camera is off, so I don't know if they're having a connection issue. But I'll go ahead and close it out from here. Again, I'm Matt Martin with PMI Georgia. You're welcome to check us out at pmigeorgia.com. You can get a free rental analysis for your property. And I see Chip, so let me add him. Chip, any final messages for us?
So next month, February 16th, make sure you come to Hobnob Tavern to join us here live in person. After you all go off the air, we're going to stay here and introduce everybody, go around the room introducing themselves and say what they're doing with real estate investing. And then with the network as well, Hobnob kicks us out of here. So just make sure you come next month, February 16th, President's Day. And we'll be right here at Hobnob Tavern in Sandy Springs near, maybe it's Dunwoody. Anyways, near Perimeter Mall. All right.
All right.
And then Matt, you'll send out some notes about what the topic will be in February, right?
Yes. Yep. Stay tuned to our LinkedIn, Facebook, and YouTube for next month's speaker. All right. Well, thanks, guys. We'll catch you next time.
Thanks.